The U.S. Supreme Court will not take up the Illinois assault weapon ban, at least not yet. The court made the announcement today.
So the Supreme Court has once again declined to review the Illinois law banning semi-automatic rifles and standard capacity magazines.
The Supreme Court will not hear the case over the Illinois assault weapon ban. The court had the opportunity to rule on whether the law should remain in effect or not while the rest of the legal battle plays out. But with this decision, the law remains intact, meaning it is still illegal for certain guns and attachments to be sold in Illinois, and anybody who owns one of these guns prior to the law being signed must register them with the state. Supporters of the law celebrated Tuesday.
Everything has been really affirming and consistent with what we had said all along, which is that these laws are legal and constitutional and they're effective.
Now the question remains, why did the Supreme Court refuse to hear this case? Well, Justice Alito would have granted the petition for writ of certiorari, which means he wanted the court to review this case. And Justice Thomas also expressed his disappointment in the denial, emphasizing the importance of the issue at hand. In his statement, Justice Thomas said, "The AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today." Now, after going over this opinion and other opinions where it was a 2A case in the Supreme Court, I'm really starting to believe that Clarence Thomas is the most pro-2A Supreme Court justice we've ever had. I swear no judge defends the Second Amendment as fiercely as Clarence Thomas does, and he doesn't get enough credit for it. He's like the 76-year-old, way smarter and way more accomplished version of Noir. And though rather short, he low-key goes off in this opinion. He criticized the Seventh Circuit's decision, stating that it illustrates why this court must provide more guidance on which weapons the Second Amendment covers. He also pointed out the court's past recognition that the Second Amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. However, he noted that there's still a lack of comprehensive framework for evaluating restrictions on types of weapons. He called out the Seventh Circuit's logic by saying the AR-15 is a civilian, not military weapon. No army in the world uses a service rifle that is only semi-automatic. He also highlighted that Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. So, what does this mean for our Second Amendment rights? Well, by refusing to hear this case, the Supreme Court has basically left the Seventh Circuit's decision in place, at least for now. This means Illinois can continue enforcing its stupid ban on semi-automatic rifles and standard capacity magazines, which concerns me a little bit because it sets a precedent that could gas up other states to enact their own assault weapon bans because they'll see it as an open season on semi-automatic rifles and standard capacity magazines. But this isn't the end of the road. Justice Thomas noted that the court is wary of taking cases in an interlocutory posture, meaning they prefer to wait until cases have reached a final judgment before stepping in. He expressed hope that the court will consider these important issues once the cases reach that stage. He also warned against relegating the Second Amendment to a second-class right, stressing the need for clear guidance on what types of weapons are protected. This case highlights the ongoing battle between state laws and constitutional protections, and it's crucial for us to not become complacent when we win other battles, because while we're celebrating those battles, we could be losing the war in the background. And don't ever let anyone tell you the Second Amendment doesn't protect the right to own an AR-15. There was one gun on this planet that the Second Amendment protects, it is absolutely the AR-15. Not because when the Second Amendment was drafted, the AR-15 was specifically what the framers had in mind, but because when they were drafting the Second Amendment, the framers were thinking, how do we protect the right of the people to own the most effective tool to preserve this free state and protect themselves? At that time, that tool was the musket, and today, that musket is the AR-15. So yes, AR-15s are protected by the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It didn't say only handguns, it said arms. So click the link in the description section and grab your AR-15s are protected by the Second Amendment hats, shirts, and drinkware at shop.mrcolionnoir.com. One thing's for certain and two things are for sure. Politicians and tech giants don't want gun content to be recommended to you. And we're all fighting this culture war together. Now you can help do your part by liking, commenting, subscribing to the channel, but most importantly, sharing this video with at least one person. Together we can stop the suppression of our 2A rights. And don't forget to click the link in the description section of this video for the products that I mentioned in this video.